Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 400 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Grooming Defense Lawyer, Southern Illinois. Accused of grooming in Southern Illinois? These cases move quickly and carry serious criminal, professional, and reputational risks. At Combs Waterkotte, we provide aggressive, discreet defense for individuals facing grooming allegations involving electronic communication, written messages, or in-person conduct. If you're under investigation or already charged, it's time to protect your rights with trusted legal counsel. What is grooming under Illinois law? Grooming is a specific criminal offense under 720, Illinois Compiled Statutes 5/1125, which prohibits using communication or conduct to lure or entice a child into sexual activity. Unlike many other sex offenses, grooming does not require physical contact. Instead, it targets the manipulative behavior that often precedes more serious crimes. A person may be charged with grooming if they communicate with someone under the age of 17, or someone they believe to be under 17, and use electronic means, text, email, chat apps, social media, etc., to engage in sexually suggestive or manipulative dialogue. Send written materials with the intent to seduce, solicit, or entice a child into unlawful conduct. Attempt to arrange an in-person meeting with the intent to commit a sex offense or distribute illegal material. The key element in a grooming case is intent. Prosecutors don't need to show a meeting occurred or that a physical act was committed. If authorities believe your words or actions were part of a plan to exploit a minor, you may be charged. Penalties for grooming in Southern Illinois. In Illinois, grooming is classified as a Class 4 felony. That means the offense is punishable even if no sexual contact takes place, and even if the intended victim was actually an undercover officer or a decoy. The law focuses on the intent and nature of the communication itself. Prison sentence of 1 to 3 years. Fines of up to $25,000. Mandatory registration as a sex offender in many cases. A conviction can impact your freedom, your reputation, and your ability to work or live where you choose. Because grooming charges are often based on interpretation of language or digital behavior, early legal intervention can be crucial in avoiding the worst outcomes. How to defend against grooming charges in Illinois. Grooming cases often rely on messages, intent, and assumptions, not physical acts. That gives defense attorneys multiple ways to challenge the evidence. We build strategic criminal defenses that reflect the specific facts of each case and protect your rights from day one. Lack of intent. You cannot be convicted unless the prosecution proves you meant to commit a sex offense. If the communication was taken out of context or misinterpreted, the charge may not stand. No actual minor involved. In many cases, the alleged victim is an adult posing as a child. If no real child was endangered, this may limit the prosecution's argument about harm or risk. Entrapment. If police created the situation and pushed you into illegal behavior you otherwise would not have considered, we may be able to argue entrapment. Freedom of speech. Not every inappropriate or suggestive message is a crime. If no explicit plan or solicitation occurred, certain communications may be protected. Misidentification or fabrication. In some cases, evidence is fabricated or digital accounts are compromised. We investigate the full chain of communication to expose weaknesses in the case. Our goal is to stop charges from being filed when possible, or get them dismissed, reduced, or defeated at trial. The earlier we're involved, the more options we have to help you. Why you need a grooming defense lawyer in Southern Illinois. Grooming charges are complex, sensitive, and often misunderstood. Prosecutors may interpret innocent or vague communication as criminal intent, and even a single online message can trigger an arrest. That's why working with a criminal defense lawyer who understands how these cases are investigated, charged, and litigated is essential. Combs Waterkotte has deep experience defending clients accused of sex crimes involving digital communication, online stings, and undercover operations. We know how to challenge chat logs, metadata, and assumptions about your intent, while protecting your privacy and constitutional rights at every stage. If you've been accused of grooming in Southern Illinois, don't speak to law enforcement before speaking with us. Charges and penalties for grooming in Illinois. Illinois law includes several grooming-related charges, each carrying serious legal and personal consequences. Here's how the most common charges and penalties compare. Charge level. Grooming via electronic communication, Class 4 felony. Written solicitation or notes, Class 4 felony. Arranging to meet a minor, Class 3 felony. Traveling to meet a child for a sex act, Class 3 felony. Repeat grooming offense or related sex crime history, enhanced felony. Penalty: 1 to 3 years in prison, up to $25,000 in fines. 1 to 3 years in prison, registration often required. 2 to 5 years in prison, potential additional charges. 2 to 5 years in prison. Mandatory sex offender registration. Extended sentencing range and mandatory registry. Hiring proven Southern Illinois criminal defense attorneys. Grooming charges demand more than general legal advice. They require focused, experienced defense. We've handled some of the most sensitive sex crime cases in Southern Illinois and understand the legal and technological complexities involved. Whether you're under investigation or already charged, we move quickly to protect your rights and tailor a defense to your case. No judgment, just a team ready to fight for you. Speak with a grooming defense lawyer in Southern Illinois today. Accused of grooming? Act fast. These cases often begin with a search, arrest, or a knock at your door. What you do next matters. Combs Waterkotte has guided clients through their toughest moments, and we're ready to protect your rights and your future. Contact us online or call 618-88-CRIME for a free private consultation.